Would you like to buy a piece of Alex Jones? Maybe a microphone that's extremely used and only partially submerged in saliva? How about a neon sign for the largest disinformation podcast in history? What about a tinfoil hat, lightly greased? Well, now's the opportunity of a lifetime because Infowars is being sold for parts to pay for Alex Jones's bankruptcy and the billions of dollars he owes people. So now's your chance. Chaos lawyer Liz Dye has more.
Thanks, Devin. Well, it's time to bust open that piggy bank because the bankruptcy court is breaking up Infowars' parent company, Free Speech Systems, and auctioning the pieces for scrap. Buyers will have a chance to purchase a little piece of history. Really, really ugly history. In December of 2022, a mass shooter stormed Sandy Hook Elementary School in Newtown, Connecticut, killing 20 first graders and 6 staffers. Almost immediately, conspiracy theorist Alex Jones claimed on his wildly popular Infowars podcast that the shooting was a false flag operation by the Obama administration. By his own admission, Jones had a huge megaphone.
You have any idea how big? I mean, I'm not even bragging. I just realized I need to throw it in the enemy's face and just laugh at them. We're bigger than the BBC and like CNN combined. We're bigger than the New York Times.
So when he called the parents of the slain children crisis actors and accused them of participating in a hoax staged to gin up support for gun control, lots of people heard him. And when he predicted that it was a prelude to a government campaign to forcibly seize Americans' guns, his audience believed him. And even though that never happened, Jones spent the next 5 years lending his airwaves to a rotating cast of kooks and liars who speculated that the slain children had never existed. Worse, Jones encouraged his listeners to do their own research, which they did, ensuring that the grieving families would be deluged with harassment and death threats, even at their own children's funerals. Some of the parents were even forced to go into hiding out of fear for their family's safety. And the reason Jones did all that was because it made him money. A lot of money. The Huffington Post reports that Infowars brought in upwards of $50 million a year between 2015 and 2018. During his, quote, final statement on Sandy Hook, which aired on November 18, 2016, not his final statement, he said, "I watched a lot of soap operas and I've seen actors before and I know when I'm watching a movie and when I'm watching something real." On that day alone, the Infowars store took in more than $100,000 flogging supplements and survival meals to his supporters. It does not seem to have occurred to Jones that there might be a price to pay for telling horrible lies about people, which, to be fair, he'd been doing for decades with very little pushback. It certainly didn't stop presidential candidate Donald Trump from appearing on his show and praising him in 2015. So Jones was probably surprised in 2018 when he was sued by 3 separate groups of Sandy Hook parents, 2 in Texas where he lives and 1 in Connecticut where they live. He certainly didn't take these suits seriously since he more or less refused to cooperate with discovery and turn over documents as ordered by the court. It was only in 2021, when judges in both states slapped him with default judgments, that he seemed to have sensed that he was in deep doo-doo. But instead of trying to negotiate a settlement like a normal person, he instead set about moving his assets. Specifically, he remembered that Free Speech Systems owed $54 million to a company called PQPR LLC, which supplied the supplements sold on Infowars.com and just never bothered to send a bill. How did PQPR forget to invoice for years on end? Well, it might have something to do with the fact that PQPR is wholly owned by Jones and his parents, David and Carol. But approximately 5 minutes after the courts entered those default judgments, Free Speech Systems, which is wholly owned by Jones himself, signed a secured promissory note purporting to put PQPR first in line to get paid before any other creditors. To pay off this debt, FSS immediately began shoveling cash out the door to PQPR, and then Jones and his company began their wild adventure in bankruptcy court, exploiting the system to avoid paying the Sandy Hook families for the damage they'd caused. The first step was to put a couple of worthless LLCs into bankruptcy on the eve of the trial in Texas. When you sue a group of related entities, you sue everyone you can to make sure that they're all on the hook together for the damages. So the Sandy Hook plaintiffs sued Jones and Free Speech Systems, but they also added in a bunch of little companies owned by FSS, at least in part to ensure that FSS didn't transfer its assets to one of those affiliated entities. But a bankruptcy filing automatically stays litigation pending against the filer. So when InfoW LLC and IW Health LLC declared bankruptcy, that put the whole Texas case on hold. Jones hoped to force the Sandy Hook families to drop their claims, and he wasn't subtle about it. Jones's lawyer, Norm Pattis, who is what you might call a character, told the Wall Street Journal, "We're turning to the bankruptcy courts to compel the plaintiffs to estimate the value of their claims in open court by discernible evidentiary standards. The plaintiffs have turned this litigation into a macabre morality play and have refused to negotiate in good faith. We hope they will show respect to the federal courts." Of course, the plaintiffs had been trying for years to settle their claims in open court by discernible evidentiary standards. The bankruptcy was actually a ploy to stop them doing just that. And Jones's opening offer in bankruptcy was to fund a litigation settlement trust with $10 million, an amount which wouldn't even cover the legal bills accrued by the Sandy Hook plaintiffs after 4 years of pretrial work chasing him down as he utterly refused to cooperate with the process. That gambit failed when the plaintiffs just dropped the LLCs as party to their state suits and marched back into court. So clearly, Jones wasn't going to be able to wriggle away that easily, and in July of 2022, he put Free Speech Systems into Chapter 11. And remember, every time you hear that FSS did something, that's Jones, because Jones owns 100% of FSS. Now, Chapter 11 of the Bankruptcy Code is for reorganization. You're supposed to negotiate with your creditors and then come out the end as a workable business. But FSS went further than that, filing under Subchapter 5, which is a provision designed for mom-and-pop small businesses like a corner store or a dry cleaners with debts of less than $7.5 million. FSS was able to do that for 2 reasons. First, because they got in right before the first jury verdict came down, which would have pushed the company's debts past the statutory threshold. And second, because the law disregards debts to insiders like, say, the owner of the company and his parents. So that $54 million debt to PQPR did not count. In August of 2022, just after FSS declared bankruptcy, a jury in Texas awarded the first set of Sandy Hook plaintiffs $4 million in compensatory damages, and then the judge added on an additional $45 million in punitive damages. That was the case where the plaintiff's lawyer Mark Bankston confronted Jones on the witness stand with proof that he was lying since his lawyers had inadvertently turned over a hard drive containing the contents of his phone.
12 days ago, your attorneys messed up and sent me an entire digital copy of your entire cell phone with every text message you've sent for the past 2 years, and when informed, did not take any steps to identify it as privileged or protect it in any way. And as of 2 days ago, it fell free and clear into my possession. And that is how I know you lied to me when you said you didn't have text messages about Sandy Hook. Did you know that?
Now that's good content. Then, in October, a Connecticut jury ordered Jones to pay $965 million in compensatory damages to the second group of Sandy Hook families, and the judge tacked on an additional $473 million in punitives. Jones laughed on air as the verdict was read, promising that the families would never get paid.
Ain't gonna be happening. Ain't no money.
Our verdict as to damages in this case, we award damages to each plaintiff and against Alex Jones and Free.
I killed the kids, folks. Listen.
In December, Jones filed for personal bankruptcy under Chapter 11. Under employment, he listed media personality and dietary supplement sales, but not journalist, which was not fake news.
Now, sorry to interrupt, but obviously if your entire life is getting liquidated to satisfy a multi-billion-dollar judgment, you'd want a good lawyer. But if you want a great lawyer, my law firm, the Eagle team, can help. If you've ever suffered a data breach, especially if you got one of those data breach letters saying that your social security number has been leaked, if you were involved in a car crash or have dealt with sexual harassment from Alex Jones or anyone else, we can represent you or help find you the right attorney. Because it's so important to talk to a lawyer right away so you can maximize your recovery or at least find out what your options are. So just click on the link in the description or call the phone number that's on screen right now for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. So click below.
U.S. bankruptcy judge Christopher Lopez has presided over all the Alex Jones-related bankruptcies, and after more than 2 years, he seems frankly worn out by Jones's shenanigans. Unlike most federal hearings, you can listen in real time to bankruptcies, but you still can't use the recordings in, say, a YouTube video. So just take my word for it, Judge Lopez is at the end of his rope. Because the entire purpose of a Subchapter 5 bankruptcy is to get the debtor out of court within about 6 months. And Jones has never done any of the things he needed to do to make that happen. He continued to file incomplete paperwork, hiding assets, and refusing to come forward with a viable plan. His best offer to the Sandy Hook plaintiffs was $55 million over 10 years to settle all claims, on $1.5 billion in damages, much of which will survive these proceedings thanks to 11 U.S.C. Section 523, which provides that debt arising from willful and malicious injury by the debtor to another entity or to the property of another entity does not get zeroed out in bankruptcy. In legal parlance, those debts are non-dischargeable because It would be bad public policy to let people commit willful torts and then use the bankruptcy system to get out of paying their victims. And Judge Lopez ruled back in October that the $4 million award to the Texas plaintiffs and more than $1 billion of the Connecticut plaintiffs' verdict cannot be discharged in bankruptcy. So Jones's offer to pay a structured settlement of like $55 million amounted to a whopping 3.6% of the debt. That's not a real settlement offer when the Sandy Hook plaintiffs are entitled to every single dollar Jones has or will ever have for the rest of his life. That's a delay tactic because Jones never intended to negotiate a settlement and reorganize FSS. The point of this exercise was always to either force the Sandy Hook plaintiffs to walk away with virtually nothing or to buy enough time that Jones and his father could set up a new platform to continue the business. Here he is at Christmas saying that they just need to get through this subchapter 5 and then they'll be free and clear.
As long as we can be solvent and somewhat profitable, then the money will go to run this operation, keep us on the air for years while the appeals go forward.
And as the months dragged on, it became clear that Jones was using the bankruptcy court in the same bad faith way he'd done in 2022 when he put those worthless LLCs in Chapter 11. And in the meantime, Jones and his dad set up a competing company, Dr. Jones Naturals, that Jones advertised for on Infowars, siphoning revenue away from the company. In May of 2024, Judge Lopez finally broke the logjam. The judge gave Jones a month to come up with a plan or the FSS case was going to get dismissed. But that managed to fracture the two sets of Sandy Hook families. Because remember, the Connecticut plaintiffs have a $1.4 billion judgment, which is almost entirely non-dischargeable. And the Texas plaintiffs have a $50 million judgment, of which only $4 million is definitively non-dischargeable. So if Jones's assets inside and outside the corporation are a pie that the plaintiffs get to share, the Texas plaintiffs are going to get a really tiny slice because their share is so much smaller than the Connecticut verdict, which is why the two sets of plaintiffs had vastly different reactions to Judge Lopez's threat to kick FSS out of court. The Connecticut families immediately requested that Judge Lopez convert the case from a Chapter 11 reorganization to a Chapter 7 liquidation, which would sell off the assets and divide the proceeds among the creditors. And that would give the Connecticut families almost all the pie, because they have a 10-figure non-dischargeable damage award. They said the Connecticut families firmly believed the interest of the estate and all creditors would be best served by conversion as opposed to dismissal of the FSS case in light of the unique circumstances. And then they try to rattle the cage by telling the court about Jones bragging on air that Judge Lopez was going to wash his hands like Pontius Pilate of the case and basically let Jones win.
The judge says a week and a half ago, no, I'm not going to liquidate and shut down Infowars. I'm going to kick it out of bankruptcy and give it back to Alex Jones, which then means the state courts and Judge Gamble and the wild-eyed Democrats can try to come in here, but he washes his hands like Pontius Pilate and he says, I'm not doing this.
The Texas plaintiffs, with their vastly smaller damage award, have different priorities, and they don't want to divide the assets pro rata. They want to seize whatever they can get their hands on. They're much better off with the proverbial race to the courthouse, particularly since they're in Texas, and so is Alex Jones, so that courthouse is local for them. They submitted their own brief reminding Judge Lopez how long Jones has dragged this thing out and urging the court to kick FSS to the curb. They said the court should order dismissal and deny the Connecticut plaintiffs' conversion motion. The Texas plaintiffs have sat on their rights for nearly 2 years, hoping a consensual resolution would be reached where FSS meaningfully pays its judgment. Enough is enough. The Sandy Hook families should be allowed to enforce their rights so they can finally move on with their lives. And then Jones himself moved to convert his personal bankruptcy to a Chapter 7 liquidation, as was his absolute right under law. Whether that's because he's already shifted enough of the assets to his father's name that he's ready to tap out, or because he saw the writing on the wall, it signaled that he finally understood he wasn't going to wring anything else out of the bankruptcy process and it was time to pull the ripcord. At a hearing on June 14th, Judge Lopez made the easy decision to convert Jones's personal bankruptcy to a Chapter 7. He really didn't have any choice. The law is clear on that one. Judge Lopez also appointed Charles Murray, an experienced bankruptcy lawyer in Texas, as trustee in Jones's Chapter 7 case. What to do about free speech systems was a much harder decision, not least because the grieving Sandy Hook families were divided. The day before that hearing, the Chapter 5 trustee, Melissa Hazelden, submitted a report detailing all the ways Jones was diverting assets from FSS. For instance, on June 1, 2024, Jones tells his followers that by supporting drjonesnaturals.com, the viewers will be supporting Jones' family as the Infowars stories, quote, overrun, done, and gone. Jones adds that his dad had set up drjonesnaturals.com because his father knew Infowars would be shut down and urges viewers to support his embattled family by purchasing from drjonesnaturals.com, and that drjonesnaturals.com has, quote, emergency stuff backed up. In fact, he was using every broadcast to send viewers to his father's store, explicitly directing them to send money away from FSS. The trustee also noted that Jones had returned to flogging conspiracy theories about the Sandy Hook shooting, speculating on June 7 that there were multiple shooters and intimating on the air 2 days later that he would soon reveal to his listeners what really happened that day. On June 10, he even attacked the plaintiffs, saying the so-called Sandy Hook families are being used by the Justice Department, by the FBI, to be the front people for this. And Jones appeared to admit on air that he was attempting to download the Infowars archive, which belongs to FSS and not him personally, potentially siphoning a valuable asset away from the company and its creditors. Hazelden noted that FSS content should not be used for any commercial purpose by any person other than the debtor. The value of any FSS property should inure to the benefit of the debtor's creditors or Jones's impending Chapter 7 estate. And she highlighted the problem with dismissing FSS from Chapter 11 while Jones himself is in bankruptcy, because Jones is the sole owner of SSS, but his incentive is definitely not to conduct an orderly wind-down of operations for the benefit of his creditors. Hazelden worried that if FSS got cut loose, no one would be able to control Jones, and he would just steal everything that wasn't nailed down and then burn the place down, figuratively speaking. Hazelden urged Judge Lopez to make really clear before kicking FSS out of court whether Jones would control the company as the 100% owner or Murray would control it as the Chapter 7 trustee in charge of liquidating Alex Jones's assets for the benefit of his creditors. And for the most part, Judge Lopez refused to do that. After a wrenching hearing that lasted for hours, he dismissed the free speech system bankruptcy, and he noted that all the parties were represented by experienced counsel, and so he wasn't going to micromanage the process other than to order the FSS restructuring officer to turn control of the business accounts over to Murray as trustee rather than to Jones personally. And then, as soon as the dismissal order was signed, every single thing that Hazelden warned about happened in short order. Within 2 hours of the FSS case being officially out of bankruptcy, the Texas plaintiffs marched into the District Court of Travis County, Texas, and attempted to seize FSS and all its assets. A judge in Texas agreed, signing what's locally referred to as a turnover order on June 24th. Murray, the Chapter 7 trustee, raced back to Judge Lopez with an emergency motion to clarify, by which he meant tell the state court and the Texas plaintiffs to stand down because all that stuff about we're all grown-ups here didn't work. Murray also asked the court to clarify that he was the one in charge of FSS's accounts, by which he meant, and not Alex Jones, in case he gets any bright ideas about paying his father or otherwise moving money beyond the reach of creditors. Unsurprisingly, the Connecticut plaintiffs agreed. They filed a motion supporting an orderly liquidation of FSS's assets and pro rata distributions among FSS's creditors that hold valid claims. They accused the Texas families of seeking preferential treatment and outsized recoveries. The Texas plaintiffs countered that Murray, as the trustee of Jones's personal bankruptcy, had no authority to run FSS, which is a corporation owned by but separate from Jones. They reminded the court that everyone involved had agreed that it was time for the Sandy Hook plaintiffs to pursue state remedies. And what else could state remedies mean besides collection actions in state court? They said, in many ways, whether the trustee or Alex Jones has management rights over FSS is a red herring. Even if this court holds that the Chapter 7 trustee controls FSS, that doesn't allow FSS to flout a state court order to turn over its property. FSS is no longer in bankruptcy. The automatic stay has been lifted. The parties are allowed to pursue available state court remedies. And the Texas plaintiffs are doing just that. At a hearing on June 27, a clearly exasperated Judge Lopez wondered in his typical fashion whether the Texas plaintiffs were being deliberately disingenuous or if he needed to draft his orders more clearly. He stayed the state judge's order and explicitly granted Murray the authority to take the reins at FSS. In the short term, that meant inviting the dozens of lawyers and accountants and appraisers to submit their invoices and get paid since they're priority creditors. which makes sense if you think about it, since professionals would never agree to work on a bankruptcy case if they had to go to the back of the line and wait to get paid like everyone else. But the practical effect of that is that more or less all the cash in FSS's accounts will be gone before any of the Sandy Hook plaintiffs get paid, which makes the disposition of the assets, both from FSS and Jones's personal bankruptcy, even more important. On August 22nd, Murray moved for a court order authorizing the wind down of FSS. He said that he'd been approached by multiple parties who hoped to purchase Free Speech Systems' intellectual property, or IP. Remember, Hazelden was worried that Jones would either expropriate or destroy the back catalog on his way out the door, and maybe the brand too. And that's why it was important, because those are where the value lies. Because irrespective of whether you think that Infowars is toxic garbage, that stuff is FSS's most valuable corporate asset, and it's the trustee's job to get the best price he can for it. Murray proposed to hold two auctions. First, selling off the IP, and then selling off the rest of Free Speech Systems' assets, like the buildings and computers and corporate cars. On September 25th, Judge Lopez agreed. Under the terms of the order, anyone interested in buying the Infowars IP will have to sign a confidentiality agreement and fully disclose the identity of each entity and each entity's shareholders, partners, investors, and ultimate controlling entities that are participating in the bid. So if, say, Alex Jones's dad, Dr. David Jones, wants to participate in this auction and buy the company's assets, he'll have to disclose that. He cannot hide behind a nest of shell companies. Bids will be sealed and accompanied by a cash deposit equal to 10% of the purchase price. All bids must be in by November 8th, with the winners notified the following week. An auction for the other assets will be on December 10th under significantly less stringent rules. All you have to do is pony up your credit card number and a valid name, address, and email. So if you've got your eye on a used pop filter or a coffee mug from the Infowars break room, now's your chance. Maybe pick up a case of super concentrated Vasobeat Complete while you're there, or an exclusive Infowars limited edition proprietary 24-karat 999 pure gold collectible. But who would actually want to buy this stuff? Well, Jones seems to think that there are any number of patriots waiting in the wings ready to put cash on the table to keep Infowars running as a conspiracy theory freak show. It's very cut and dry that the assets of Free Speech Systems, the website, the equipment, the shopping cart, all that can be sold, he said on a recent show, and they know full well that there are a bunch of patriot buyers, and then the operation can ease on. He did not say whether those patriots include his daddy or whether he intends to rely on the kindness of strangers. And to be clear, weird things have happened. In 2022, an anonymous donor dropped $8 million of Bitcoin into Infowars coffers, which Jones pocketed. But if the IP isn't snapped up by one of Jones's supporters, it might well end up owned by his detractors. Independent media outlet The Barbed Wire is fundraising to purchase some of the FSS IP assets. Editor Jeff Rotkoff wrote, "We'd like your help to make some mischief by buying Infowars and using it for our absurd, joke-filled progressive journalism purposes. Jones has said he hopes patriots will buy the company, keeping him employed and on the air. What if we do literally anything else with it?" There are a lot of ways this could go down, and don't forget, Jones's personal bankruptcy is still going on. Here's Jones crying on air in June about being forced to sell his ranch, something he blamed on the FBI, CIA, and the Democratic Party.
We're going to beat these people. I'm not trying to be dramatic here, but it's been a hard fight. These people hate our children.
In reality, his own lawyer requested the court's permission to sell that property. That's not a game he's going to continue to be able to play with Murray babysitting as trustee. In fact, as the parties were hashing out the details for that auction of the Infowars IP, Jones's only concern was protecting domains that contain his name, which he claims cannot be owned by any other than him personally, and his personal social media accounts. Murray explicitly excluded those things from the FSS IP auction, but he suggested in the hearing that he intends to revisit the issue when he disposes of the assets in Jones's personal bankruptcy. So if you ever wanted to buy the @RealAlexJones handle, maybe you'll get your chance. And there are two remaining cases involving money Jones moved out of FSS when he realized he was about to get sued into oblivion. One alleges that Jones fraudulently transferred some $18 million to himself and to PQPR in anticipation of the litigation. That was originally filed in Texas state court and removed to the federal court. The other case, also filed by the Sandy Hook plaintiffs, alleges that the notes Free Speech Systems signed acknowledging that $54 million debt to PQPR were fraudulent and unenforceable. Remember, that's the company wholly owned by Jones and his parents. Both cases are in front of Judge Lopez, who's probably regretting his career choices about now. It ain't over till it's over, but we do appear to be entering the final inning. Thank God.
Thanks, Liz. For now, Alex Jones is still broadcasting, but his days may be limited. And Alex Jones is one of the many things that are still out on the internet that can hurt you, which is where today's sponsor NordVPN comes in. Because incognito mode isn't actually incognito. Google actually got sued over this. But with NordVPN's no logs policy, your internet service provider doesn't get to snoop on what you're searching, and neither does NordVPN. I've personally been a long-time user of NordVPN, and I especially like to use it while I'm traveling and using unfamiliar networks, which we all tend to do a lot this time of year. And NordVPN is more than just a great VPN. It comes with a whole suite of threat protection tools. For example, if you follow some of your favorite creators on social media, you might have heard of stories of a channel getting hacked, basically a creator losing access after a successful attack or leaked password. This happens way too often. But NordVPN's threat protection includes specific features to warn you about phishing links, as well as features like a blocker for malicious ads and dark web monitoring to alert you if your passwords have been leaked. And of course, NordVPN is still a great VPN. With Nord, you can surf the web anonymously and your location stays private. It allows me to set my location all over the world, which lets me access different versions of my favorite websites. And when I'm out of the country and try to connect to my Gmail or a bunch of other things that I'm logged into, all those accounts would normally freak out and tell me that I'm being hacked. So now I just reroute my connection to the US and my Gmail and everything else is happy. And not only is Nord the fastest VPN on the planet, but you get 24/7 customer support to help you whenever you need it and a 30-day money-back guarantee for all users. So if you'd like to give NordVPN a try, click on the link that's on screen right now or down in the description. Every purchase of the 2-year plan will receive 4 bonus months on top, and it's completely risk-free with Nord's 30-day money-back guarantee. So click on the link that's on screen right now or down below and get 1 free month with a huge discount and a risk-free 30-day money-back guarantee. And after that, click on this box over here for more LegalEagle, or I'll see you in court.